It's the news of the week. The trial went exactly the way everyone, I guess, wanted it to. But Robert, everybody knows what happened. $965 million in damages. 120
just to begin with. They're going to add more. That's going to be about $1.5 billion when they're done.
Yeah, I think. Pat has said it's going to be maybe $2 to $2.5 billion because they're going to have punitive legal fees, etc. Biggest award was $120 million to Robbie Parker, $90 million to the FBI agent who had no family members get killed in the incident. The worst that was said about him was that he was an actor, that he might not have been an FBI agent. He didn't wear the right bat, whatever. Harassment associated with that, $90 million, and it goes down to $2.8 million. Some are saying the trial went exactly the way the judge wanted it. Others are saying the judge has to be a plant, has to be there for Alex Jones because this is so absurd. It's so preposterous. It cannot but get overturned on appeal. Robert, I mean, the triple fakey false flag, one thing. This is over the top, is it not? Or is it?
It's utterly absurd. It's utterly absurd. It is the biggest verdict in the history of libel lawsuits by a ratio of about 100x. So it's about 100 times bigger than any kind of verdict like this ever. And again, most of the people who recovered damages, all but one, I believe, that recovered damages in this case, Alex Jones never talked about ever, including the FBI guy who didn't lose anybody at Sandy Hook, who admitted on the stand, we covered it live, admitted on the stand that he didn't know he had never seen Alex Jones identify him by photo, by image, by name, nothing. And yet he's allowed $90 million.
I think the worst thing that the FBI agents testified to and admitted to was that the harassment actually started even before Alex Jones covered the story.
Completely. And that the FBI investigated it and decided there were no criminal charges to be brought, which has to raise a question about exactly how accurate he was in that information relayed. If people were really harassing an FBI agent to the degree of death threats, things like that, that's a crime. They would have been investigated. They were investigated, apparently, and they would have been prosecuted. They weren't, would suggest that something wasn't quite up. So it's a laughably absurd verdict. It's the clown verdict to a clown trial. And it should surprise no one, given what a complete crock that trial was. The only kind of person it could shock, or not shock, is, say, someone who purports to be an independent, big trial, free speech advocate on YouTube, and is like, I'm not sure if it's $1 billion. I'm not sure. When people had raised questions, including on our locals board, why I was particularly critical of certain law tubers who chose not to cover this trial, and also showed in their other behavior that they're not reliable, not trustworthy people. My view is that if you're going to be an independent commentator, your only utility is to actually be independent. If you're going to be a free speech advocate, and a big trial covered person, you can't ignore the Alex Jones trial and use willful blindness as your excuse for, I'm not sure if $1 billion is too much or not. That's the kind of person that's like, should I be loyal to someone who gave me my whole channel or not? And so those kind of people, by just random tidbit, don't complain about people asking about who your husband works for if you say that because you're a military spouse, we can't question your commitment to free speech. Also, don't complain about people asking for photos if you've got 4 photos behind you in the video.
I'll tell you one thing. We're not set aside the YouTube drama, Robert. I think everybody set aside the YouTube drama. There were a lot of people who were not following it and equivocating, and also just if you didn't follow it, it would have been a weird thing. But then to express an opinion is problematic. It's when people say, I didn't follow it, no opinion whatsoever. I wonder if David French followed it because he had some strong opinions. This is what happens when you defame people, yada, yada, totally bypassing the fact that there was no trial on the merits and the trial on the quantum. To say Jones had 2 hands tied behind his back would be an understatement of the millennia. But this is the issue that also people don't really understand. It's $965 million compensatory damages, not punitive, not, I don't know what other types of damages there could be, but not punitive. So Connecticut law,
they had no emotional expert that I know of to testify to any emotional damages. They had no reputational damages from an expert that I saw. So again, this is, in many states, you wouldn't even be allowed to argue emotional distress if you don't have emotional expert proof. And so everything about it was absurd. And so my reason for calling out certain commentators who have failed to cover this case is like legal bites, completely failed to cover this case in a meaningful way. Don't pretend you're a free speech advocate, because you're not. I call her out to call everybody else out that is taking a neutral Pontius Pilate type position on this. This is as big. You cannot claim to be a free speech advocate and say this verdict is okay. You just can't. There's no honest, credible coverage of this case or review of this case. The verdict itself should scream that out to you, that this is a core attack on free speech in America. This is, we can write billion-dollar checks to people based on speech offending them. I mean that's what Alex Jones is being held responsible for. There was no evidence that Alex Jones stalked anybody, harassed anybody, doxed, none of that. The only evidence was Alex Jones spoke out, and because of his speech, we're blaming him for everything else that happened. But let's be clear, they're blaming him for his speech. And it's not a traditional defamation claim at all. Doesn't fit the constitutional defamation at all. So to transition into what appeal rights he has, so his appeal, the first and core appeal, is the First Amendment to the United States Constitution. State courts cannot weaponize state tort law to punish speech. This was the point of New York Times versus Sullivan and its successor cases, including Westboro Baptist. That's been clear over and over again. So it doesn't matter how you denominate it. Much of the damages, contrary to David French's position, was not actually defamation. It was consumer product damages, even though they weren't alleging any injury from the consumer product. I mean, that's how nuts. They're trying to take all these other areas of law and find new creative ways to punish dissident speech. And to be clear, the legal theory they had in this case is that if a major incident occurs, that there's now a legally protected safe space, that you cannot comment on that topic if it will upset and offend anybody within that zone of danger, within that legally protected safe space. Even if you never talk about them. Doesn't matter if you talk about them. Doesn't matter. The constitutional requirement of colloquium is the second thing this violates. So the first constitutional violation is they're simply punishing speech using state tort power, which they legally cannot do. Secondly, if to be outside of that, it has to be a classic case of defamation, and that requires that there be a factually false statement about a specifically identified individual that then causes reputational injury. That wasn't met here, and they ignored that. And the courts have been clear they're ignoring that. They're rewriting the law to say that the constitutional requirement of colloquium is what it's called. People can go back and read the New York Times versus Sullivan case. The second part, everybody talks about the actual malice standard. That's only part one of that case. Part two of that case is they said constitutionally, there's a requirement of colloquium, which means the statement has to be about that person specifically. So they said in that case, it was clear that that individual was within a zone of danger, within a legally protected space, because the statements were made about the police hierarchy, and he was only one of a small group of people that was within that police hierarchy. But the Supreme Court said, nope, that's not enough. You have to specifically identify the individual. Now, you can identify an individual by pointing out their photo. You can identify an individual if they're in such a small group that there's no doubt it's about that person. So let me give an example. Let's say somebody says, LawTube is filled with a bunch of loser grifters that don't know anything, etc. Can Viva sue? No, there's too many LawTubers. But what if they said, Viva and Barnes are a bunch are lied about, Well, then either one of us can sue, because that's a specifically small enough group, right? Or the 5 people on the Ricada channel on day X did something false. Well, that's a small enough group. The old case is New York. The case came out of New York. 2 different lies were told about Macy's employees. One lie was about a group of Macy's employees that only had less than 25 workers in it. The other part had a department that had more than 100. The court said, more than 100? No way you can sue. Less than 20? Okay, we can see that. Problem here is the number of people within the legally protected Sandy Hook safe space, again, including FBI agents, was thousands of people. Because they claimed that you didn't have to be someone who died. You just had to know someone who died. You didn't even have to know someone who died. You just had to have some connection to it. Just be an agent there, investigated it, talked about it. Well, that's thousands and thousands of people. That has never been allowed in the history of libel law because it violates the constitutional requirement of colloquium. So that's his second grounds to object to all of this. The other grounds include complete denial of his right to trial by jury, misuse of what's called the death penalty default judgment, which stripped him of his right to trial by jury, and due process of law. Then you have violations of misapplying the consumer product statute to something that doesn't concern consumer products. Then you have all of the evidentiary violations that occurred in this case. As Norm Pattis said, in studying all the cases he's studied and being part of all the cases he's been part of, no case in Connecticut has ever done what this court did at any level. And this included ridiculous interpretations of the rules of evidence. And that's why I call out, if you're going to purport to be an independent legal commentator defending free speech, you lose all credibility with me when you don't cover the Alex Jones trial. You lose what little tiny bit might be left when you're not sure if $1 billion verdict is absurd. I don't take any legal commentator anywhere seriously that thinks $1 billion verdict is just fine or is not sure if it's bad. It's laughably absurd, and everybody knows it.
People have to appreciate it's compensatory damages. So they had to show the damages for which they're being compensated. $90 million for the FBI
with
agent.
No expert about emotional harm, no expert about reputational harm. I mean, it's unheard of. This is utterly unheard of, utterly unprecedented. You won't find another verdict like this anywhere in the history of the world. It's 100 times larger, the average. I can tell you from focus groups and jurors, it's about 100,000 times larger than the average jury verdict was given when they heard both sides. So that's why they had to rig this trial. This was a show trial. It was with a clown judge, which resulted in a clown verdict. And it's a disgrace to the rule of law. But here's the hurdle. All the law is on Alex Jones' side, but few of the judges are. So unless a lot of noise is raised in the court of public opinion, the Connecticut Court of Appeals, the Connecticut Supreme Court, the Austin Court of Appeals will do nothing about this. They've already eviscerated his rights in prior cases. They've created, like everybody said, hey, can't we use the Alex Jones precedent to go after all these other people? I guarantee you they'll suddenly rediscover the law. This will all be Alex Jones exceptions to the rules of evidence, to the rules of due process, to the rule of trial by jury, to the right of freedom of speech. And if anybody had any doubt what the purpose of this, and remember, folks out there, over 90% of the people who suffered a traumatic loss at Sandy Hook have never blamed Alex Jones, have never sued Alex Jones, never sued the gun company. This is a tiny, politically active group. And if you had any doubt about that, and by the way, Norm Pattis was denied the right to cross-examine them on this political bias, wasn't even allowed to say the words Hillary Clinton in trial when she was the reason for this whole lawfare being instigated and initiated and originated in the first place. But if you had any doubt about it, just like the plaintiff's lawyer in Texas, plaintiff's lawyer walks out, and is he looking at collecting money? No. He says, hey, everybody out there, stop supporting Alex Jones. Don't give any more money to Infowars. Don't give any money to Alex Jones. Now, why would you do that if your point was to recover for real damages of your clients? Never seen a plaintiff's lawyer do that in my life. Why? Because this whole case was about suppressing, silencing, censoring, shaming an independent, populist, dissident voice that they hate.
Okay, the grounds of appeal. Let's just say, as far as the colloquium, or we don't know who was being referred to in the statements. If I put them on a hierarchy, I would put that one a little lower because there are only so many parents of Sandy Hook. It's true down to the extent that
it, right? Then the FBI guys got to be
well.
Out.
That's where they open.
Siblings. I mean, do you include the siblings or not? The issue is there's no doubt, there's no dispute factually that he didn't identify almost any of these people by
with
name.
The exception of Robbie Parker, who got the biggest award of $120 million.
Correct, and only in one context because they're suing him for a bunch of other statements. 99% of his statements didn't concern Robbie Parker. So and then in the Texas case, he never referred to either one of those. So historically, it's been, if you don't refer to them, it has to be they have to be of such a small group. The parents don't even count because the limit has usually been 20 to 25. And here's the way to think of it. The idea is that the reference is so obvious to that person, even because they're of such a small group, that everybody knows who you're talking about. The problem here is they didn't even know who these parents were. They didn't even know who these people were. The excuse of the Texas Court of Appeals in Austin was, well, maybe they could find him on the internet. And it's like, hold on a second. That's never been our standard, that you can look up and research and independently investigate who the statement might possibly refer to. That's never been the claim. So that the constitutional requirement of colloquium is his strongest argument from it, because it's a federal issue. It's a constitutional issue. It's an issue that the U.S. Supreme Court can get involved in. A lot of the other claims are specific to Texas or Connecticut law.
My issue, Robert, with the colloquium is that as a matter of fact, will be relatively easy for them to say, well, there were there were 20 some odd victims. Therefore, when he says they were crisis actors, he can only be referring to the parents of 20 some
or
odd people.
Siblings.
So
and that's well over the 25 max historically.
Of those who
parents
gave
are well over the 25 max. That's
okay.
the issue. And so that's why they knew from day one they had a major hurdle. That how do you sue for defamation when you're not referenced and when you're a part of a group that's too big historically? So I'll give you an example. I had a sufficiently small number of Covington kids that were specifically identified by photo. Could I have sued for all 80 Covington kids that were there that day? No. And everybody agreed no. It was only the people that were identified by image, because that's how. Remember the Kentucky Fried Chicken case? There are only like 25, 30 Kentucky Fried Chickens they could have been referring to, but that 25 has been the cap, and often they've gone below that. And the reason they've gone below that is it's got to be obvious the group is so small that you can't help but think, oh, that's a reference to that person. And the problem is that just wasn't there, because not only that, these people weren't publicly known or identified as well. So, if you'd put them up by photo, if you otherwise, then there's a different argument. But that wasn't the case here, and that was the problem. So you have the Robbie Parker case, which could be separated out, but then it should be only that statement about Robbie Parker, not all the statements that are just about Sandy Hook in general. And none of it justifies compensatory damages. This makes our American civil court system look like a joke.
The one thing is $1 billion, divided among 16 plaintiffs. Okay, so it's only $120 million for defamation and intention, IIED. Still preposterous. Robert, what I love also, though, is the people out there who are clamoring. Stephen Goldstein, Jones would not provide discovery, yada, yada. David and Robert are in the same boat. They will not follow discovery. Well, Stephen, following your last thread of a message, I hope you have $1 billion. Unless you think that, some people get to say whatever they want and others don't. And also,
anybody who watched the trial could see that the default death penalty sanction was ludicrous. Because the plaintiffs had all the evidence they ever needed. In fact, they had more evidence. And I'll say this again, Alex Jones produced more discovery than any media defendant in the history of libel law.
But someone's going to
find an analogous case where somebody was issued a death penalty default judgment. I've challenged lawyers to do it. They haven't been able to find one in the history of America.
Well, that part, I don't think it's a matter of fact. If anybody finds a decision where a media defendant was death penaltied default verdict for not turning over discovery documents, fine. Robert, what people will say, and it's the rebuttal, you could turn over 10,000 documents. If you don't turn over one, and it's the critical one, I still don't think
that's never grounds for default. It's not a ground for the court to strip you of your right to trial by jury. They have to find extraordinary claims. It has to be default death penalty sanction is considered for people who are not participating in the proceedings. Number one. No, so clearly that didn't apply here. Alex Jones sat for hours and hours and hours and hours and hours of deposition testimony.
It is true that they deposed him even after the default verdict.
Yeah, exactly, multiple times. I mean, so it was just absurd. So that's part one. Part two is there has to be a strict connection and no lesser remedy. There was no strict connection. What was it they didn't have? They didn't identify anything at trial they didn't have. They knew how much money he made, how much gross revenue came into Infowars by date and time. So what they did is for those that don't know, how they got to default judgment was, give us the evidence that you're guilty. No, I'm not guilty. I'm innocent. Aha! You have denied us the evidence that you're guilty. We hereby declare you guilty by default. That's what happened. That's what was always going to happen, because their fake case, supposedly about fake news, was in fact a fake case. They were blaming Alex Jones for things he was not responsible or accountable for. And the goal is to weaponize the legal system to suppress, censor, independent dissident speech. And they will never apply this Alex Jones precedent to anybody on their side of the political aisle ever, but they may apply it to others on the Alex Jones side. And people, and I think the other disturbing thing about this, Martyr made this point on Twitter, and I increasingly agree. This idolatry of victimhood that this case also celebrated, which was, hey, I suffer a terrible tragedy. Now I get to tell you what you can do. Now I get to line my pockets with your money. I'm morally superior now. You can't question my case. You can't question my judgment. You can't question my action. I'm the king victim. This is a dangerous ideology, a dangerous idolatry that undermines society's core values, and we should reject it outright.
Just reading some of the chat now, Robert. Okay, so setting aside the legal standard of appeal on that one question, colloquium, Eighth Amendment violations, is that even conceivable in this context? I mean,
not so much. It wasn't technically a fine; it was a civil judgment. So it's still more of a First Amendment issue. It's the misapplication of these laws to reach speech that violate the First Amendment. So the broad one is, the first one is colloquium. The second one is a broad category that this is the state courts weaponizing state torts to punish speech in violation of the First Amendment in a way that is not carved out, that there's no exception to. And so that's the big constitutional claims. There is also the right to trial by jury and the right to due process of law.
Is that not the strongest grounds for appeal? Like one of the reasons, at least in Quebec, judges don't like dismissing cases until they go to the merits is it makes it so much easier to appeal. They say, I never even got to a hearing on the merits. This judge, default verdict and stripped. Is that not the strongest grounds for appeal? Like they would have to show clear and unequivocal evidence that would justify the judge imposing that sanction.
Because it requires a deep dive factually, it tends to be a less appealing appellate issue. Mm-hmm. So the misuse and abuse of default power is a major problem here, but the courts are less likely to jump in as they are on the First Amendment issue. Because the size and scale of the verdict is embarrassing to the judiciary. Because this makes it look like our American legal system is a complete crock. Nobody thinks anybody suffered $100 million in damages because of what Alex Jones said. That requires ludicrous logic. And to give an idea, less than 1 out of 10,000 jurors were of that inclination. They managed to stack and rig the case in such a way that they could induce that outcome. But so I think those aspects are the real constitutionally attractive issues for the courts to be concerned about. What are the limits? Because there are no limits put here, and our traditional constitutional limits were eviscerated. But he also has the federal constitutional issues of trial by jury and due process of law, also state constitutional issues of trial by jury and a range of other issues. The statute of limitations was not enforced here. That's both a due process issue and a statutory issue. And then there's all the violations of the rules of evidence, a range of violations on jury instructions, if there was a rule to be violated, the judges in these cases violated them. They were obsessed with a shambolic verdict against Alex Jones that would scare and terrorize his supporters from ever supporting him again, and and anybody like him from rising up. That's what the case was about. It was open and overt. It was not about really about compensation. In his opening statement, the plaintiff's lawyer made clear what he was there for: give a big enough verdict so that Alex Jones can never be on the air again. That was the goal.
People are asking this, is Alex going to be able to survive this? Will it deter people from? I mean, the thing is, the money that he makes, it's not from super chats, and I guess it's not so much from donations. So it's not like people are going to say, I'm going to stop donating, because that's not primarily where it comes from. Product sales and whatever, and people are still going to buy it because they're still going to get a product for it. Have you noticed any deterrence on a fan base to say any money we give him is now going to go to pay these families, so let's stop supporting Alex, to some extent?
Yeah, he's fought back against that directly, because any money that comes into Infowars just keeps Infowars on the air. If there's any excess profits, then the families can profit from that excess profits, but there hasn't been a lot of excess profits. So so his goal is just to keep Infowars on the air, any way, shape, or form, while he fights this through the appellate courts and the court of public opinion. And I think they were hopeful the verdict would be so big that it would shut down Infowars. That's not going to happen. In fact, the irony is this: Jones would have retired several years ago, but for this case. He was kind of exhausted. He'd done a lot of work over a quarter century, achieved a lot. And he was ready to just to say, hey, I've done great work. Good luck, everybody. But because they tried to silence him, because they tried to censor him, because they tried to shame his audience for supporting him, is why now he'll never go away. And they're right. In the end of the day, Alex Jones is uncancelable, and they'll discover that the hard way.
Let's see this here. It's those colloidal silver junkies supporting him. By the way, great stuff to keep you not sick. No medical advice.
Silverware. So we use silver. I mean, silver's been around for centuries as something that's good for you.
Yes,
right?
but Robert, you eat off silverware. You don't eat silverware. So just so that everyone, there's no medical advice here. But hold on, I had one more question about Alex Jones. So compensatory damages, no limits. Not that it makes a difference on this amount. Is there a cap on punitive damages under Connecticut? Like it's a factor of the compensatory damages?
There is in certain cases. There is not in this bogus consumer fraud case they brought. So we'll see how much of a joke the judge is. Does she issue some ludicrous punitive damages award to show how much she was in on this fraud on the American people? And but I think a lot of people thought maybe I was exaggerating or overstating the case. Now they realize I was, if anything, understating the case. That this case is a direct threat on free speech, a direct threat on dissident opinion, the continued weaponization of our legal system to suppress and oppress voices. It's not new. During the civil rights era, American courts in the South did everything they could to shut up the civil rights movement. That was why New York Times versus Sullivan went up. They went after Westboro Baptist because they didn't like their opinions. That got a crazy $77 million verdict that got the Supreme Court's attention to being like, no more of this. So the size and scale and scope of the verdict is such a big warning sign. You saw people like MIA and others be like, hold on a second. This seems a little nuts.
Not that I'm not citing people on the left as authority. I'm just citing people who are on the far left, vouch, laughing his ass off. It's hilarious in the insanity of a $1 billion judgment, even if it's divided among 16 plaintiffs. Everybody knows that it's absurd. It's just that some people who are present in the chat love this injustice, so they can use it to threaten other people to shut them up. So, I hope you have $1 billion. That's the new standard. $120 million. Anybody want to, question or ask questions about the Armenian genocide? $100 million. Something that hurts people's feelings who have suffered from a tragedy. $100 million. That's the new standard. And people love it because they think that the rules are only going to apply to them to punish their ideological adversaries, and they can continue calling Trump a Nazi, a rapist, and whatever, and that's it. That's how it's going to work.